Okay, hello everyone. As an outside counsel, we have the privilege of learning about many different businesses and industries in our work on deals and cases for our clients. I chose the career path of a TMT lawyer so that I could combine my two areas of study, being computer science and the law, and be involved in the business of technology through the practice of law. In the time I've been practicing, I've helped clients launch innovative technology platforms, break into new markets, and find ways through regulatory barriers where the path isn't always clear. It's exciting work, particularly in a region like the Asia Pacific, where no two markets are the same. Every year, the tech gets better and the deals get bigger, more interesting, and more complex. And my career has seen a number of waves of work driven by business model and technology advances, including outsourcing, the independent tower model, greenfield tower rollouts, greenfield fiber rollouts, cloud computing, mobile innovations, operator carve-outs, crypto, metaverse, and now generative AI. So the job of the TMT lawyer hasn't changed, but due to new technologies and the business landscape changing rapidly with increased demand for compute and bandwidth and associated investments, the job is getting more intense. At the same time, for operators, the regulatory environment is constantly changing, driven by technology advancements, geopolitics, and national security considerations. Investors and operators are facing this change in real time. We primarily advise our clients on risk, but in most cases it is in the balancing of risks that our clients succeed, given the sheer complexity of the environments they're operating within. If you're an investor, operator, or platform in the digital infrastructure space in 2024, the opportunities are immense, but so is the complexity. My name is Connell O'Neill. I'm a partner at Gibson, Dunn Crutcher, and lead our APAC, digital infrastructure, TMT, AI, privacy, cybersecurity, and data innovation practices. I'm based in Hong Kong and cover markets spanning from New Zealand to Saudi Arabia and beyond. I've focused on digital infrastructure for my entire career, covering data center transactions, tower deals, fiber rollouts, subsea arrangements, and satellite. Monetization of assets has been a theme during this time, but only in the past few years have we seen such a massive uptick in demand for data centers and connectivity driven by advances in technology, in particular AI applications. When considering the technology landscape in Asia in 2024 and over the past few years, the overarching theme has been one of capacity constraints and demand, which has been outstripping supply. Putting aside China as a market, where I do agree it has been suppressed by policy, as mentioned yesterday, demand across the region has been steadily increasing. As we help our clients to address this increased demand, an overarching theme in our work has been how to comply with existing laws and regulations and how to prepare for regulatory change. Today I will walk us through some of the key challenges for the technology sector and the region and try to highlight practical approaches to addressing them. So what are the most pressing regulatory challenges currently facing digital infrastructure investors and market participants in Asia? Various regulatory challenges arise for participants across the digital infrastructure ecosystem, depending on the specific market, project, and/or asset. Therefore, participants need to be aware of and alert to the regulatory challenges and changes that may affect their investments and operations. However, digital infrastructure specific challenges generally arise at the operational level rather than during the development or investment phase, putting aside planning regulation and other environmental regulations which may be specific to particular markets and jurisdictions. Many laws and regulations that apply generally to any project also apply to digital infrastructure projects, including licensing, permitting, taxation, ESR, intellectual property, and others. There are relatively few individual or specific laws and regulations to digital infrastructure that apply on a regional basis and that impose requirements on projects and their investors during development. In any case, it's difficult to cover specifics across jurisdictions unlike the EU or the US, which tend to have more of a harmonised approach. There is no overarching governing regulatory framework in APAC, so we end up with a patchwork of different requirements reflecting different legal systems, political regimes, cultural norms, and development stages of countries in the region. So turning to our first and probably the most impactful area of regulation we're currently facing, which is data protection, privacy, and data sovereignty regulation. This is relevant to digital infrastructure participants in that digital infrastructure assets fundamentally enable the collection, processing, storage, and transfer of massive amounts of data, including personal and sensitive data. As a result, any investment in, operation, or use of these assets inevitably implicates data protection laws. The business of investors, operators, and in particular their customers, are rarely limited to individual geographies. As we've heard, in the region we're seeing the emergence of platforms, and so we almost always need to consider the implications of transferring information offshore. The regulatory environment in this space in APAC, we've seen many countries in APAC enacting or updating data protection laws in recent years. We've seen the introduction of omnibus laws in many countries in the last 5 years, and various other jurisdictions are in the process of law reform. Most APAC jurisdictions have generally followed the example of the EU GDPR, which is largely considered the gold standard for data privacy regulation globally. But they almost always these regimes almost always have local nuance to reflect different legal systems. Omnibus laws have been enacted recently in China, Indonesia, Thailand, Vietnam, and India, and they all have different and unique local requirements. These laws are familiar to almost every business in 2024, but they impose various obligations and restrictions on data controls and processes, such as obtaining consent, ensuring security, notifying breaches, and complying with data subject rights. Of particular significance for participants in the digital infrastructure ecosystem, these laws impose cross-border transfer limitations and requirements, or in some cases introduce data sovereignty requirements. We've been hearing about this as a particular concern for the industry during the course of yesterday. These data sovereignty requirements mandate the local processing or storage of certain types of information within the local jurisdiction, and or the obligation to obtain authorization for cross-border data transfers. Recent examples of data localization laws include the data security law in China, which is mostly focused on national security outcomes, but requires the data collected and stored within China to be maintained within the geographical boundaries. We've also seen the introduction of data localization law in Indonesia, although more constrained in its application. And in India, initially the draft bill was quite an expansive data localization requirement, which has been reduced down to a blacklist maintained and published by the government. So what we've seen is a creation of a patchwork of overlapping data regulations that are difficult to reconcile in practice. We often are asked questions on a regional basis, and there is very little harmonisation when you get into the details of the law and its application in different jurisdictions. There are implications of this for operational architecture and for digital infrastructure investors, operators, and their customers across the region, who need to balance the efficiency and scalability of their operations with the compliance and sovereignty of their data locations. The next major area, which is an area of focus for digital infrastructure, is that of cybersecurity regulation. And this is relevant as digital infrastructure becomes more interconnected and interdependent, and also becomes more vulnerable. As that increases, it also becomes more vulnerable and exposed to cybersecurity threats and attacks, which can happen at any level in the stack, right from power generation all the way up to the technology that's residing on top of the digital infrastructure. Now, these attacks can take the form of hacking, phishing, ransomware, denial of service. We're all familiar with these types of attacks. They can cause serious damage and disruption to digital infrastructure and the data it carries, as well as the reputation and trust. So the regulatory response, which is developed in parallel with data protection reforms across the region, has been to introduce legislation which requires the adoption and implementation of robust and effective cybersecurity measures and systems, such as encryption, authentication, firewalls, and backup. These laws and regulations variously require digital infrastructure investors to report and to coordinate with authorities on any incidents, and to comply with the cybersecurity standards and auditing. An example, the cybersecurity law in China, which regulates how organizations and businesses should protect digital information, including whether and under what circumstances it can be transferred outside of mainland China. In Singapore, there are proposed amendments to the Singapore Cybersecurity Act, which would broaden the focus beyond critical information infrastructure onto covering systems of temporary cybersecurity concern. So this is an area of ongoing focus across the region, both generally in terms of law reform and when we talk about specific industry regulation. So the next area that I'll cover is one that has come up a lot in the last couple of days, which is that of AI regulation. And this is obviously relevant to market participants in that it holds particular significance for digital infrastructure investors and operators due to the unique nature and operation of digital infrastructure and the critical role it plays in the digital economy, which increasingly involves or is driven by AI innovation. Digital infrastructure provides the backbone to the training, development, and operation of AI through cloud computing, data centers, and networking services. Many of the large technology companies are either digital infrastructure investors themselves or customers of investors or operators, and are at the forefront of AI innovation and technology, and therefore also tend to be the primary target of AI regulation. The implication of this is that they will require their service providers to enable them to comply, and this may result in the mandating of architectural requirements and drive particular adoption within specific favourable jurisdictions. And when we talk about the regulatory environment for AI, the approach to this differs greatly jurisdiction to jurisdiction. It's evolving in the Asia Pacific. We're currently in the process of consultation in most jurisdictions, but we are on the brink of the introduction of AI regulations, both at the industry level and generally in terms of omnibus regulations. As for data protection and the GDPR, what we are likely to see is a Brussels effect, which is effectively that the regulators will wait to see the outcomes of the introduction of the omnibus laws in the US and the EU, like they did with the introduction of the GDPR, and tend to hold off the introduction of laws in this region until they have a good understanding of that. So if we look at the different approaches to AI regulation, there's many different dimensions to this. We have sectoral versus horizontal regulation. In Hong Kong right now we're seeing financial sector AI regulation. In other markets we're seeing horizontal regulation. There's light touch versus comprehensive, and again, different jurisdictions are favouring light touch. Certain jurisdictions are favouring comprehensive, such as China. We see centralised and decentralised approach, and we also see guiding principles versus prescriptive requirements. So it's very different depending on which jurisdiction you're looking at. In the meantime, there are varying approaches to AI-specific regulation and guidance. China, centralised distributed approach with various regulators responsible for regulation. Hong Kong, it's a sectoral approach leaning towards self-regulation, complemented by horizontal cross-sector guidelines. Singapore is, I think, favouring itself as a favourable jurisdiction for AI. It's adopted a light touch approach with a focus on fostering AI innovation instead of legislation. It's published AI best practice guidelines and testing frameworks and toolkits. In Taiwan, has proposed a single comprehensive legislative framework in the form of a draft basic law on artificial intelligence. So moving on to, this is not my area of practice, antitrust regulation, but giving this presentation without touching on it would be missing a huge area of focus. It's relevant to digital infrastructure market participants because digitalization is fundamentally changing market structures, including by creating new markets and altering the way that market players compete. This challenges traditional approaches to competition and in turn calls for new legislative and regulatory tools for effective scrutiny. In particular, data has become the new gold. We've all heard that said. The access to which has now become a key parameter for market power and dominance. The assessment of network effects has also emerged as an important consideration in analysing the relevant markets and competitive effects in digital mergers. So what we are seeing is competition authorities all over the world trying to catch up with the evolution of digital markets and placing increasing scrutiny on investments in digital infrastructure and assets. The last area of regulation that I'll touch on, again, it is not my practice area, but it's something that is important to acknowledge, is the area of sanctions and trade controls. And the best example to point out is what's happening in the US concerning China, where all branches of government are taking an all-of-government approach when it comes to China. We have multiple federal agencies and regulations covering sanctions, export controls, inbound and outbound FDI controls, tariffs, and more. The promulgation and expansion of rules, including brand new programs, has been astronomical over the past 4 to 5 years, and it seems like this will continue. The stated approach so far has been couched in terms of high walls, narrow field, meaning greatest emphasis has been placed on strict controls when it comes to areas such as AI, quantum computing, and semiconductors. So how do we prepare for regulatory change? How can investors prepare themselves to weather the storm? This is not an easy task, as the regulatory landscape for digital infrastructure is often fluid and fragmented, and it really depends on the asset type, and it's subject to frequent revision and interpretation by different administrations, regulators, authorities, and courts. Some general principles and best practices that digital infrastructure investors and operators can follow to enhance their regulatory readiness and resilience include conducting thorough and ongoing due diligence on the regulatory framework and risks in each market and on particular projects, covering not only formal laws and regulations, but also the informal practices and expectations of the regulators, policymakers, and stakeholders. And this requires engaging with local experts, whether that be consultants, lawyers, and other connections locally that can help to identify developments and trends, as well as the potential pitfalls and opportunities. We also recommend adopting a proactive and collaborative approach to regulatory compliance and engagement by establishing and maintaining good relationships with the relevant authorities and agencies, seeking guidance and feedback and loudly demonstrating a commitment to and contribution to the local market and society. This can ultimately help build trust and goodwill and avoid or resolve any regulatory issues or disputes that may come up. I would underscore the importance of establishing strong relationships within specific geographies on both sides of the table. We also recommend developing and implementing a robust regulatory strategy and governance framework that can adapt to the changing regulatory environment and requirements, and that can address and mitigate the regulatory risks and challenges. And this may involve setting clear and consistent policies and procedures, allocating roles and responsibilities, conducting regular audits and reviews, and providing training and education to staff and partners. We also recommend preparing and executing a contingency plan and a crisis management plan that can deal with any unexpected or adverse regulatory change or events. So then in terms of practical measures, operational measures, we tend to focus on careful consideration of products, services, and structuring, and where and focus on where you want to fall within the regulatory purview. And that will really depend on the nature of the asset, the nature of the services provided. But having a thorough understanding of where you fall is important in terms of future planning. We recommend adopting contracting provisions which allow flexibility in the event of a change of law or regulations. We stress careful vendor or subcontractor and customer diligence and selection, and the allocation of liability and responsibility and reporting SLAs. It's better to do this always up front and be very clear about where responsibility lies, so that in the event of change in law, change in regulation, it's clear who does what and where the cost lies. In light of intensifying geopolitical tensions, how do we balance the need for compliance with local regulations while still pursuing innovative and potentially disruptive opportunities? There is no simple answer to this one, as it depends on the specific circumstances and objectives of each investor and each investment. In addition to the best practice principles I outlined, we would recommend ensuring that the diligence and origination phase covers not only current and expected laws and regulations, but also the potential economic factors, the social and cultural factors, and the competitive and technology factors. We underscore that this exercise is not simply legal or commercial, and there is a need to develop a holistic understanding of each jurisdiction and market to be able to see around corners and to be able to build confidence about what is possible versus impractical. We stress adopting a selective and strategic approach to thematic investing by identifying and prioritizing the markets and projects that offer the most attractive, sustainable opportunities, while also minimizing and managing the regulatory and geopolitical risks. This may involve diversifying, allocating portfolios across different markets and projects, partnering with and collaborating with local and regional players, and helping and ensuring against the regulatory and geopolitical uncertainties. I'll leave it open to questions, if anybody had any questions on the presentation. I guess not. Wanted to thank the Tech Capital for inviting me to present today, and I hope you all enjoy the rest of today's sessions, and I look forward to sharing a drink with you in the afternoon. Thank you all.